Now, before I go to tenancy in common, I just want to make sure that you understand. Now, we say under the analysis of trust, we would have two levels of owner, legal owner and equitable owners. What if they are different versions? The example, X is the legal owner, Y is the equitable owner. Then, can X occupy the land and prevent Y from entering in? Now, the answer is no. Because we have a maxim, just like the equity starting. When common law and equity are equal, equity prevails. Legal owner, equitable owner, so they are equal. Now, when they are equal, equity prevails. The equitable owners would prevail over the legal owner. And if you still remember, I said earlier, if you hold 100% of the equitable interest, you can always compel the holder of the legal ownership to convey that legal estate to you. So it is always the equitable owner who has, higher authority, so to speak, than the legal owner. And another point I want to say about tenancy, joint tenancy, before I go to tenancy in common. I don't know whether you have heard about this term called 長命契. That is joint tenancy. It has nothing to do with at lease. It actually refers to joint tenancy. So if you purchase a property with another person, the lawyer may ask you whether you want to hold the property under a 長命契 or not. Don't show a blank face. You should know now. Oh, you are talking about joint tenancy. Yeah, of course, or of course not. Okay, tenancy in common, the other legal form for more than one owners holding the property at the same time. It is also known as undivided share in land. So there is a share of interest in land, but that share is not divided. And under this form of co-ownership, each tenant in common owns separate shares in the land. But those shares do not attach to a particular portion of the land until it is divided up physically. So if it is not divided up physically, then all tenants in common will own each and every square inch of the land together. That is to say, under joint tenancy in common, there is unity in possession, as in the case of joint tenancy. And that's why my warning in the previous lectures will apply no matter you and your spouse are holding the property as tenants, a joint tenant or tenancy in common. So when you do not allow your spouse to enter the bedroom, think twice, okay? Now, what is the nature of tenancy in common? It can be summed up by Lord Denning in the case Wu and Wu. Here we are talking about the son and mother. The son is the legal owner, is registered as the sole owner. So the judge said, the son is of course the legal owner of the house because the house was registered in his name. But the mother and son are, I think, equitable tenants in common. Because the mother has also proprietary interest in the house, even though her name is not used to register. She holds equitable ownership. So she and the son are equitable tenants in common. Each is entitled in equity to an undivided share in the house. That's why we say tenancy in common, sometimes known as undivided share in land. The share of each being in proportion to his or her respective contribution to the purchase price. Until a sale takes place, these equitable tenants in common have the same rights to enjoy the land as legal tenants used to have, where when there are two equitable tenants in common, then until the place is sold, each of them is entitled concurrently together at the same time with the other to the possession of the land, unity in possession, and to use and enjoy of it, of the land, in a proper manner, and that neither of them is entitled to turn out the other. So, the question, this is still the judge speech in the case. The question may be asked, what is to happen when the two fall out as they have done here? Son and mother fall out. The answer is that the house must be sold and the proceeds divided between the mother and son in the proper proportions according to their share in the land. So that is the concept of tenancy in common. Now, physically, unity in possession would allow each tenant in common to occupy every square inches of that land. But their share may not be the same. Depends on the proportion of contribution they made to the purchase of this property. If it is a 20-80 proportion, then they would own 20 or 80% of the equitable interest of that property. But this 20-80 is still a notional idea, because the concept of unity in possession would not say, oh, since you own only 20%, you are only allowed to make use of 20% of this piece of land. No, that's not the case. Unity in possession, even though one co-owner only owns 1% or less than 1% of the equitable interest, he would be entitled to enjoy the entire piece of land. But when the land is sold, then his interest is only 1% out of the sale proceeds. And since it is not joint tenants, their interest is not united together with the full unity, only one unity, a tenant in common is entitled to do with his own undivided share in any way without joining the other tenants in common. So in theory, tenants in common may even grant a lease or license to a third party without the consent of other tenants in common. And the other tenants in common also cannot revoke the lease or license without joining the grantor. Because this concept of unity in possession, say for example, I rent out the entire piece of land to a third party. He has this joint tenant, this tenant in common, do have that right. Now, if that is really the case, then the remaining joint tenants in common, even though he may have a greater share, he cannot just unilaterally terminate the tenancy granted by the tenants in common with minority share. And he has to join the minority shareholder to terminate the tenancy or whatever. Now, in a recent case decided in 2015 in Hong Kong, Court of Appeal explained the separate and distinct interests of tenants in common. Of course, a tenant in common could deal with his own undivided share as he liked, and he could licit or dispose of his right to possession to to a stranger without the concurrence of the other co-tenant. In other words, I own 30% of the undivided share of this piece of land. I can sell my 30% to a third party without asking the holders of the remaining 70% to agree or not, or join it. And he can also enforce his interest on his own without joining the other co-tenants. And right of survivorship does not apply to a tenancy in common. Therefore, when a co-owner dies, his share will be passed on to his estate. Now, if a property is held under tenancy in common, then a will do work for transferring the share toward a beneficiary under the will. And I have already mentioned that only one requirement of unity in possession. So it means if one tenant in common owns only minority share, this tenant in common is still entitled to enjoy the entire property without restriction. And there are 4 equitable presumptions for tenancy in common, even if legal estate is held in joint tenancy. So in the legal estate, you can, because Section 9(1) require an express provision in the instrument. Say, for example, this house is assigned to A and B in joint tenancy. It only applies to legal estate. But what about the equitable interest? Now, we have certain presumption to deal with the existence of tenancy in common. Number 1, the purchase of land in unequal share of money. If the property is purchased in this way, 2 or more owners join purchase or contribute to the purchase price of a house, for example, in unequal share, then the presumption would be they are holding the equitable interest of this house under tenancy in common. The purchase of land by a partnership, partnership refer to form of a legal entity in carrying on business in Hong Kong. You can form a limited company or you can form a partnership. For example, the lawyers, the solicitors in Hong Kong are running their business in the form of partnership. Okay, so if a solicitor firm purchases a property, then the presumption would be the partners of that solicitor firm are holding the equitable interest of the property under tenancy in common. The co-ownership of mortgagee, well, this is a little bit technical, and we'll come back to this concept when we talk about mortgage and charge. Mortgagee, remember, they're the creditor. They borrow, they lend the money to the debtor, to the borrower. Now, when 2 or more mortgagee creditor advance money on mortgage using the property as security, the share of the interest of this mortgagee in respect of the land used as security is tenancy in common. So, regardless of the fact that the mortgage loan was in equal or unequal shares. And when the mortgagor, the debtor, the borrower, is in default of payment, would not pay the mortgage repayment, the mortgagee take possession of the land. So that is how they enforce that mortgage against the mortgagor. Now, if that really happened, the different mortgagee will hold the land as tenants in common. So they are co-owner, but their share would be held under tenancy in common. The fourth presumption is when properties are held for several individual business purposes. Now, that is a case, the Malayan Credit Limited case, in which four persons jointly purchase a property. They make equal contribution to the purchase price, but they are using that is a shop actually for four different purposes. One is use it for selling something, the other use it as a tailor shop, etc. So four different business purposes. And the court said that, well, it's clear that they do not want to hold the property under equity or in equity as joint tenancy, under joint tenancy. The presumption under this scenario is that the equitable owners are holding the interest, equitable interest under tenancy in common. Now, at the end of the day, whether a co-ownership was created as a joint tenancy or tenancy in common in equity is a matter of common intention of the co-owners, if it is possible to ascertain this common intention. Because we are asking, the court is asking, what did the co-owners intend when they purchase a property? Do they want to hold it under a Chang Lam Kai or not? So evidence about their common intention will be adduced in a trial for the court to make a decision whether in equity the equitable interest should be held under joint tenancy or tenancy in common. Of course, if you have a piece of writing, saying that both parties sign on that piece of writing, oh, we are holding this property under joint tenancy in equity, is of course very straightforward. But in most cases, particularly when the two parties are lovers, when they purchase the property, they would not care this kind of format. But this particular module, land law, tells you that, well, love is blind. Everything must be clear-cut. And therefore, in relation to land property, the law requires creation by deed, creation in writing and signed by parties. You must make everything clear, and evidence, good evidence to support the original intention. Now, but of course, if married couple, the different presumption would apply. There is a presumption that married couple holding the legal estate jointly are also holding jointly the equitable interest of the property. So if any of the couple wants to hold the legal estate jointly with his or her spouse, but holds the equitable interest in the form of tenancy in common, this person must have adequate evidence to rebut this presumption. Maybe you ask or your spouse to sign an agreement, or you ask him to make an oral statement and take down the statement as evidence. That would be best. Now, co-ownership of legal estate, how to transfer the interest. If the co-ownership is held under joint tenancy, it is necessary for all the legal joint tenants to join in the conveyancing. Conveyance means transfer of interest, transfer of proprietary rights. Remember, joint tenancy, 4 unities. Unities of title, unity of interest. So everything is joined together. So if you want to transfer the legal interest, no matter legal estate or equitable interest, must have all the joint tenants act together. If one joint tenant dies before the conveyance, his interest in the joint tenancy, of course, goes to the other joint tenants under the right of survivorship principle. And if that really happened, the surviving joint tenants can transfer the legal estate without any prior transfer of the deceased joint tenant's interest to them. Now, in that case, because it is an operation of law, you do not need any instrument, anything in writing. But how can you prove one joint tenant died? The death certificate of that joint tenant is very important as evidence. You produce the death certificate of the joint tenant. That means the right of survivorship would have applied, and the deceased interest would automatically transfer to you. And if it is not any it does not involve any person dying, then the legal estate must be transferred by deed. For tenancy in common, it is possible for each individual tenant in common to transfer his own undivided share to a third party without joining other joint tenants in common. Okay? So, as I said, I own 20% of this piece of land. I want to sell my 20% to you, but I can do it myself without asking the permission of the others holding the remaining 80%. But if the entire legal estate, if we are talking about the entire piece of land, is to be transferred, then of course all tenants in common must join in the conveyance, in the transfer. And if you want to transfer the legal estate, it must also be by deed. So sign, seal, and deliver. All the joint tenants would have to sign and put their seal. Of course, deliver, then one person deliver that instrument to the transferee would be enough. But all the parties would have to sign and put down their seal. Now, that is for legal estate. For co-ownership in equity, each individual co-owner can dispose of his own equitable interest if the co-ownership is held under tenancy in common, just like the legal ownership held under co-ownership. And any transfer of the equitable interest, remember, must be in writing and signed by the co-owner in question. If the co-ownership in equity is held under joint tenancy, then the right of survivorship will also apply. An individual co-owner cannot deal with the land without joining the other co-owner. Okay? So that feels like sum up everything in relation to co-ownership held under joint tenancy or tenancy in common, no matter we are talking about a legal estate or equitable interest. Now, you can change your mind. You love your partner. So, as I said, love is blind, so it's just, oh, okay, I'll sign the 長命契. But later on you find, wow, this guy is not really trustworthy. Or I better keep my own share. Now, you can do that. And that act is called severance. Joint tenancy can be severed to become tenant in common. But you cannot join a tenancy in common to become joint tenancy. So under Section 8 of CPO, a joint tenancy of an estate, legal estate, or interest, equitable interest, in land may be severed at law. That is, we are talking about recognized by law, only by, number one, a notice severed by a joint tenant on the other joint tenants, or by an instrument. So if you have two joint tenants holding the legal estate of a property. You want to cipher it for equitable interest, or what you want to cipher it, and to make everything clear cut, you do it at law. You will have to serve a notice, of course, written notice to the other joint tenant, telling him that, well, after all, after second thought, I want to keep my own share in my own name. Okay? So the joint tenancy will then cipher by law under Section 8. Or an instrument, both of you agree to, talking about legal estate, both of you execute a deed to be delivered to each other. From now on, we are holding this property in joint tenancy in common. Instrument means a legal document. Subsection 2, joint tenancy of an estate or interest in land may be ciphered in equity by a notice served by joint tenant on the other joint tenant. So we are talking about equitable interest now, or by any other method that is effective in equity, or that would, but for subsection 1, be effective at law. Now, so the more difficult part is really the second part, any method that is effective in equity, or but for subsection 1 be effective at law, because we have to rely on previous decision of court. If certain way of cipherance is recognized by court as effective, then they can take advantage of subsection 2 for ciphering the joint tenancy in equity. So, as a joint tenancy, remember, it could not be by will. So the instrument, when the word said instrument, it could not include a will, even though a will is also a legal document, is also an instrument. So under subsection 8(1)(b), the instrument can be any document having legal effect, including an agreement, contract, to transfer the equitable interest, but not a will. For legal estate, okay, again, to make things easier for you, the notice of ciphering must be in writing, but need not be signed. Okay? This is for cipherance, but not for creating or disposing an interest in land. So the requirements are different. For cipherance, no need to be signed, but it must be in writing. If the notice is sent by post, now you can serve the notice face to face, of course, but you say, well, it's embarrassing to inform my previous lover that I want to cipher this property, so I better send him a letter. Well, if you want to do that, it is enough if it has been duly posted to the other joint tenants, even if it is not received by them. So it is similar to the postal rule. Remember postal rule in the contract law? Once you drop it into the mailbox, even the other party have not received this acceptance, the contract is already effective. So for notice of cipherance, again, once you duly post that letter to or containing the notice to the other joint tenants, it would have effectively ciphered the joint tenancy in legal estate. And in general, the service, that means to serve this notice to the other party, must comply with Section 62 of CPO. First of all, notice must be in writing, served by leaving the notice at the last known place of abode or business in Hong Kong of the other co-owner or by post. So other than by post, if you know where this guy is living, you can just leave the notice at his door. Of course, in that case, it is better for you to at least take a picture or videotape the entire process. Otherwise, it will be difficult to prove you have served the notice when the other guy said, I have never seen this notice left in my address. Thus, a document served in court proceeding may be a notice for the purposes of cipherance if the intention to cipher is clearly shown. So, for example, you hold a property jointly with another person, and then you sue him for whatever reason, and in that statement of claim, you also make reference to this ownership, that you no longer want to hold this share as joint tenant, or impliedly suggest that that would be adequate for the purposes of cipherance. But that intention must be to cipher immediately and not to cipher at some time in the future. So otherwise, you will not satisfy the requirement under Section 62. Where there is a deed of cipherance, now you want to cipher the legal estate, that you must have a deed. The title to the cipher's share rests on the assignment. Assignment is the assignment which assign that property to you jointly, and the deed of cipherance. Now we have, although the property was assigned to us jointly, now with this deed of cipherance, we have ciphered the joint tenancy into tenancy in common. So you must have both. Otherwise, it would not be good enough to show the legal estate has been ciphered. For equitable joint tenancy, under Section 6, subsection 2, any notice referred to above for ciphering legal estate will also cipher equitable interest held in joint tenancy. Of course, in that notice, you have to make reference to the legal equitable interest. Cipherance in equity may also occur in the following scenario, and these are from the case law. When one of the co-owners unlawfully kills the other, remember the case in UK, if you unlawfully kill the other co-owner, it would serve to have ciphered the joint tenancy into tenancy in common. Where there is a mutual agreement, no matter whether the agreement is oral or written or enforceable at all. So this is cipherance in equity. So as long as both parties agree that the joint tenancy should become tenancy in common, then even though there is lack of consideration, so that the agreement is not enforceable under contract law, that would be adequate for the purposes of ciphering the joint equitable interest into equitable interest held under tenancy in common. And in one of the case, Burgess, it was held that an agreement made between joint tenants for one to buy out the other share was sufficient to cipher the joint tenancy. You are saying that, well, why don't you, I agree to purchase the share of the other joint tenants. That would be a clear indication that they no longer want to hold the property as joint tenancy. So even though the agreement was not in writing, remember we're talking about the contract for interest in land, it must be in writing and signed. But for the purpose of ciphering, it is not required to have that agreement in writing. And in the other case, Gore and Shell, it was held that an agreement in principle would not be sufficient to to effect a severance. Agreement in principle would be things like subject to contract. Remember this concept in your law of obligation. If we say, I agree to sell this property to you subject to contract, that is too vague to be enforceable. So simply agreement in principle would not be adequate for ciphering a joint tenancy in equity. And an act of any one of the person's interests operating upon his own share. So one of the joint tenants enter into an enforceable contract to transfer his share to another person. If that's the case, then that is an effective way to cipher the joint tenancy into tenancy in common. But if there was a mere declaration of an intention to cipher, well, I really planning to cipher, or I intended to cipher, you're just saying such an intention, that would be insufficient to cipher a joint tenancy unless it is incorporated in a written notice. And lastly, any mutual cause of dealing amongst the joint tenants which are sufficient to intimate, that means to show that the interests of all joint tenants were mutually treated as constituting a tenancy in common. So this is a little bit vague and general, but it at least give us some guidelines for cipher joint tenancy in equity under by not really serving a notice to the other. And the dealings must show an intention that the parties are to be tenants in common rather than joint tenants. Now, in fact, remember this guy, Lord Denning, he always create new legal principles. In the case Burgess, he actually tried to suggest that, well, inconclusive negotiation between joint tenants would be sufficient severance, but the majority of the Court of Appeal disagree. So this is only his opinion, but this is not a good law. And in Gore and Shell, it was held that it was possible to have a cause of dealing even where the negotiation broke down. And in a recent case in Hong Kong, the court held that a charging order registered against interests of surviving joint tenant alone did not constitute severance, so that the surviving joint tenant was entitled to right of survivorship upon the death of the other joint tenant. Now, what is a charging order? This is an order. Usually, it has to begin with a judgment debt. What is a judgment debt? Judgment debt means that in an action, for example, a contract dispute between A and B, A said B is in breach of the contract, so he wants damages, to claim damages. And the court, after the trial, agreed with A. B is in breach, so B has to pay a sum of damages to A. Now, before B actually pay up this sum of damages, it is described as a judgment debt. That is a debt created as a result of a court judgment. Now, when you have a judgment debt, it does not mean that, in our example, B will automatically pay up the sum of money to you. So you want to enforce this judgment debt against B. One way is you make a land search to see whether B has any real property in Hong Kong. He has a flat in Tai Kwu Sing. Very good. Then you can make use of this judgment debt and go to court and ask the court to give you a charging order. Charging order, and this charging order can be registered against the interest of B's in relation to the flat in Tai Kwu Sing. Now, and if B still fail to settle this judgment debt, A would be entitled to go to court again and ask the court to make an order for sale of the property. If the court gives you the order, you can sell the property and collect from the proceeds of the sale the judgment debt. So that is the meaning of charging order. And the court in that case held that if you are talking about getting a charging order and register against the interest of the surviving tenant, it does not mean that the joint tenant himself interest in the land would have been cipher under the joint tenancy. Because a charging order has the same effect of an equitable charge, and it entails it involves no disposition or alienation of any proprietary interest to the chargee, to the one who get this charging order. So it could not have cipher the joint tenancy. It is not the joint tenant himself deal with his own share of the joint held under the joint tenancy. Okay, so that's about the law you have to know in relation to co-ownership, tenancy in common, and joint tenancy. And in your exam, it is more frequent to have questions on joint tenancy. For unity, right of survivorship, for example, and for tenancy in common, the more common question would be on, that is actually a recurring question. No, I'm not the examiner, but this question is loved by examiner. He said, well, what is the advice you will be given to a couple or unmarried couple? Married couple depends on what this examiner wants to ask you. When they jointly purchase a property in relation to the co-ownership or the way to hold this property, and then you have to answer that. If they are married couple, there would be a presumption that if they hold the property, legal estate under joint tenancy, then it would presume that the equitable interest will also be held under joint tenancy. So I will, if this couple really wants to enjoy the right of survivorship, they should expressly purchase this property as a joint tenant, something like that. Or if it is an unmarried couple, you have to warn them that no such presumption would be applied. Then you have to think carefully whether you want to hold the property under joint tenancy or tenancy in common, something like that. We'll come back to exam question in the revision class. Just talk about that in passing. Okay, that is about co-ownership. But two or more persons holding the legal estate or equitable interest at the same time, then how can such co-ownership be terminated? Co-ownership of land comes to an end when the property is sold, of course, and is sold to another owners, or when it is vested in one particular co-owner. For example, one co-owner dies and the other co-owner takes the entire title by way of right of survivorship. In that case, only one owner is holding the property. But what about when both parties are healthy and young, but they fall out? One party wants to terminate the co-ownership by selling the property, and the other say, no, I want to keep this property. Well, what can they do to settle this dispute? Now, in Hong Kong, we have an ordinance called Partition Ordinance. Partition means to cut the land physically up. So that co-owners may apply to court to divide up physically a piece of land, if it is a piece of land. If it is a flat, of course, you cannot do that. So that each party hold one section of that land singly. Or if it is impossible to physically divide up the land, then they can apply for an order for sale to sell that property so that the co-owners can share the proceeds of the sale. Now, what about parties agree? We agree to petition. In that case, of course, you do not have to go to court. You can do it by agreement. But of course, always remember Section 4.1, legal estate in them must be created, etc., by deed. So if you want to have an agreement to petition the land, if you want to get legal effect at law, get the legal estate by the co-owner after the land is physically divided up, then you have to do this agreement by deed. Agreement to petition by deed. Now, if an agreement cannot be reached, and any parties interested in the land can apply to court, as I said earlier, for an order for sale or order for petition of the land under the petition ordinance. And of course, once the land is sold, the co-ownership terminates. Once the land is being physically divided up, co-ownership also terminates. Now, Section 2 of the petition ordinance provides that subject to this ordinance, where any property in land is held by two or more persons, so the land is held under co-ownership, whether as joint tenants or as tenants in common, the court may, three options. A, make an order under Section 4 for a petition of the property, that is to physically dividing up the property. B, make an order under Section 6 for sale of the property. This is usually applied for any other land interest which cannot be petitioned. And sometimes the court may refuse to make any order, that is to preserve the co-ownership. Now, in relation to petition, Section 4. Section 4.1 said, the court, if there is any application and proceeding, the court may, subject to subsection 2 of Section 4, make an order for the petition of the property in land in any of the following ways: into parcels held by single owners in severalty. It means a big piece of land cut into smaller pieces of land. The smaller pieces of land is referred to as parcel of land. So, into parcel held by two or more owners as joint tenant, and into parcel held by two or more owners as tenants in common. Well, that means, say for example, you have a big piece of land, and you have three co-owners to begin with. Now, the court can do it this way, cut this into three parcels according to the percentage they hold, because even tenants in common can take advantage of the petition ordinance. So each person, A, B, C, each one hold one parcel, that is A. And alternatively, the court can do it this way. C, A, and B holding this part, and C holding the other part. Either A and B hold this part under joint tenancy, that is B, or holding it under tenancy in common, that is C. And may petition the property in all those ways or in any combination of them and give all necessary proper consequential direction. So the court has a great power and discretion to deal with the actual petition of that big piece of land. Now, Section 2 talk about more technical things, which is not really that important. The court just say, well, if you have a building on this piece of land, the petition must be done so that the building will be entirely included in one parcel. Say, if there's a building on this board, you cannot petition the land in such a way. And if there are, say, three co-owners, only two of them wants to petition the land, then the order made by the court should not have any prejudice caused to the last owner who has no intention to petition the land. Now, of course, petition is only possible if we are talking about a piece of land. If we are talking about a flat, the court would have no option under Section 4. And the more usual order would then be an order for sale under Section 6. Now, Section 6, the wording is where it appears to the court that a petition of the property would not be beneficial to all the person interested. The court may make an order for sale of the property. So it is not just whether it is possible to physically divide up the land. The court has also taken into account the interest of all the beneficial owners, whether dividing up the land would be in the interest of all the persons. If at the end of the day, even though it's a big piece of land, the court finds that it would not be beneficial to all persons interested, the court would not petition physically dividing up the land, but make an order for this land to be sold and the co-owners to share the sale proceeds. And under this section, the law also, the ordinance also give suggestion or guideline to the court to decide whether the physical petition would be beneficial to all persons interested. Factors that the court must take into account, including the nature of the land. If it is a flat, as I said, it's impossible to physically divide up a flat. Then, of course, the only option would be order for sale or do nothing. the number of persons' interest and the absence of the or disability of some of the person's interest. Now, and under that section, section 6, subsection 3 and A, the court should also take into account whether one or more co-owners would like to keep the property intact without any partition. If that is the case, the court may give that person an option to buy out the interest of the party applying for the order for sale. Say, again, we have three owners here, A, B, and C. B, make an application to say, oh, I want this land to be sold. But C wants to keep the land. And if, of course, depends on whether he has enough money or not. If he has enough money, he may suggest to the court that, well, B wants to sell the property, so his ultimate aim is to get money. I will buy his share out. Now, if that's the case, then the court would not make the order for sale, but allow C to make a payment to B, of course, fair market price, to acquire the share of B. Now, but in a situation like this, what about A and C? Both of them say that, well, I want to keep the property. I want to buy B's share. If that's the case, under the current design of Section 6, the court cannot do anything. It would create an impasse when more than one other person's interest undertake to purchase the interest of the party applying for an order for sale. And that's exactly what happened in this case. And court also have power to direct the distribution of the proceeds of the sale, as well as the manner that the sale be conducted. For example, put up the sale, the property for auction, or in any other way to ensure the market price can be acquired. Now, any person interested in Section 3 was construed to mean any person in possession of the land. Now, in possession, remember, this is a special term. It refers to, holding some proprietary rights, and not simply physical possession. Now, for example, in this Fortis Bank Asia Hong Kong case, the bank received a charging order, get a charging order against the property. We explained charging order already. And this guy, after getting this charging order, tried to apply under Section 6 for an order for sale, to sell the property. But that application was not entertained by the court, by reason that the holder of a charging order actually has no interest, no proprietary interest in the property itself. So they are not any person in possession, as required under Section 3 to make the application under Section 6. And not physical possession was illustrated in this case. Now, in this case, the property in question was a matrimonial home of an unmarried couple who co-owned the property and lived together with their daughter. And the court held that daughter, even though she was living in the property, but she was not a person in possession because she had no interest, no proprietary interest in the property, and therefore has no locus standi to sue under Section 6. And when deciding whether or not to make this order for sale or order for petition, the court also taken into consideration of the original purposes of acquiring the land by the co-owners. For example, the flat was acquired for matrimonial home, then, the court would take that into account. And if the couple was still under marriage, then normally court would refuse to make any order. But if the couple were in divorce, the original purpose to hold this, to keep this property as matrimonial home, then the court would be more ready to make the order for sale under Section 6. Or, if in another situation, just like here, we have more than two owners, and majority of the owner, A and C, want to keep this land. If that's the case, then the court may allow both A and C to purchase the share of B, so that the property can be kept in accordance with their original purpose. So, creation of co-ownership and termination of co-ownership has been covered. Now, we come to a very important topic. We say, if you own a piece of land, you are not just owning the physical land. You own all the soil down to the piece of land and airspace up to a reasonable height. And you have the right to claim ownership of precious article found on the land where the real owner could not be located, etc., etc. Now, what ownership? What is the nature of ownership when you own a flat? Because that is not the right way to describe ownership of flat under the legal analysis. Now, the most common type of ownership co-ownership can be found in the area of matrimonial home, because both husband and wife joined in, or or at least they hold the property as tenancy in common, and multi-story buildings, and subject to the new territories land, the concept of land held by Joe or Tom, there is actually no such concept of family home or family property at law in Hong Kong. Now, this house belongs to my family. That is not a legal concept recognized in the law of Hong Kong. We can only establish ownership according to the common law principle. And at common law, the court only recognize money. If you pay the purchase price, you pay the mortgage installment, then you would acquire beneficial owner of a property. But ownership can also be established by law through resulting or constructive trust. Now, we have in the early of this class, we have referred to this concept. Resulting trust should be clear to you now, and constructive trust refer to trust which did not exist but was constructed by the court in given circumstances. There is also a doctrine called proprietary estoppel. You have learned promissory estoppel in your contract law, but now you come to a new concept called proprietary estoppel. Promissory estoppel deal with promise, and proprietary estoppel deal with proprietary right. And under this proprietary estoppel, a Persian may be allowed to remain in a property indefinitely, even though he may have no proprietary interest in the property. Now, how does this concept of who paid the purchase price, mortgage installment, may acquire the beneficial interest? It actually comes from this presumption of resulting trust. You purchase, you make payment, then the court will presume that you are acquiring the beneficial interest. That is the concept of resulting trust. And in a Hong Kong case, rather recent case, the court held that if the Persian has paid the purchase price, the retention of the title deeds refer to the documents that show the ownership of the land, starting from the government list. We'll come back to this concept later when we deal with conveyancing in detail. So title deeds we can just understand as book kai. Title deed was a significant piece of evidence to show the keeper of the title deed was a beneficial owner. Now, the problem is, as I said, love is blind. And that coupled with, in the old days, women were having an inferior position in relation to their standing in a relation between a man. In the old days, particularly in England, women were not allowed to work after they married, or even they worked, they could not rise to the the upper the top level of a company or a business. So the typical scenario in the old days would be when a woman married a man, they would remain at home as housewife. Or even they work, they would not be the one who paid the mortgage installment. And coupled with the practice in the past, when a house is purchased, it would be registered only in the name of the man. But you see, even though I'm a man is not trustworthy. Okay? When they get more money, their heart will change easily. So they may, met some younger, more beautiful woman, and then want to divorce their wife. Now the problem happened to the wife. They only live in the matrimonial home, for example, but their name was not registered as the owner. And they have not made any direct contribution to the purchase price or mortgage installment. But they said, well, I have married to this man for so many years, taking care of the children. I pay their school fee, I purchase certain furniture, or pay the utilities. I should have an interest in this property. It is because of my contribution, my husband can have spare money to pay the mortgage installment. Very persuasive. But the judges will say, oh, I'm sorry. This would not help you to acquire any beneficial interest in the land. Now, typical scenario, the weaker party. Now, of course, I'm aware of the change of the society. Women are now earning much, much more money than men in many cases. So I use the word weaker party. In the past, I would say the woman. The weaker party stay at home and contribute his or her labor to improve the house, take care of children, so that the other party can go out to work and earn money. When the relationship breaks down, the weaker party is kicked out. That is hard reality, because he or she has no legal estate in the house in question. The classic case is Gissing and Gissing. In Gissing, House of Lord held that indirect financial contribution by wife over 25 years did not, I highlight this word, create a beneficial interest in the house. The indirect financial contribution took the form of general household expenditure. And the wife actually argued by paying this item to free his husband's income for the mortgage payment. But House of Lordships held that this did not give rise to a constructive trust, as contribution must be directly referable to the acquisition of the property. So remember this. If your darling says, oh, darling, you have a good job. If we are in default in payment, it would affect your future. Okay, let me shoulder all this trouble. Just register property in my name. Okay, don't worry, I will take care of it. Don't believe him or her, okay? You say, oh, I really love you as much as you love me. I cannot allow you alone to take this risk. Let me shoulder the risk with you together. Okay, this is really important, okay? And in the other case, Lloyd's Van, the wife carried out substantial work on renovation of a derelict farmhouse, which was eventually intended as the matrimonial home. But the court held that there was no indirect contribution which could show a common intention between the parties or the wife to have an interest in the property. And there are actually many other cases, such as Parsi, Burns and Burns, etc. All this, naughty man kick away the wife when she becomes a bit older. Don't trust English man. Ultimately, in this case, Grant and Edwards, similar facts as in the above case, the Court of Appeal held constructive trust exists. Now, but there are special facts in that case. Now, what happened in this case is a woman who is divorcing her husband met a man. They lived together and purchased a house. And the man said to the woman, now you are having this. Oh, sorry. Okay, let's finish this story before we finish the class. Now, now you are having this divorce litigation with your husband. If you purchase a property, then it would affect your share of your husband's money. So forget about it. Let me register as the owner. But of course, this man said a little bit more. Don't worry, I will allow you to have a share of this property. All this was, recorded down by the woman. And later on, I say, man could not be trusted. This guy changed his heart for another woman and wanted to take that woman away. And the woman claimed that she should have equitable interest in the property. And the court said that, well, the evidence is clear. There was a common intention that the house was to be commonly owned. The woman's name was not put just because there was a pending matrimonial proceeding. Therefore, the court said that we can construct a trust in this situation. The man is the legal owner, holding the equitable interest of the house on himself, for himself and the woman. And in that case, the woman get a share in the equitable interest. Okay, we'll continue on Wednesday.